What if I told you that the United States federal government made a secret deal with a serial child sex offender and then deliberately hid that deal from his victims? Not forgot to tell them, not delayed notification. Deliberately, intentionally, actively concealed it. While those same victims were being told by federal prosecutors to be patient, that their case was still being investigated, that justice was coming. The deal had already been signed. The victims just didn't know. For years they didn't know. And when they finally found out, they went to federal court to challenge it. A federal judge agreed with them. He ruled the government broke the law, and nothing happened. No one was punished. No one was fired. The deal stood. Stay till the end. Because the ruling that confirmed this betrayal changes everything about how you understand this case. I'm Mark Epstein, and this is the Epstein Files. The law at the center of this episode is called the Crime Victims' Rights Act. It was signed into law on October 30th, 2004, as part of the Justice for All Act. Its federal citation is 18 U.S.C. paragraph 3771. Congress passed it with a clear and unambiguous purpose: to guarantee that victims of federal crimes had specific, enforceable rights within the criminal justice system. Among those rights, the right to be reasonably informed of any public court proceeding involving the crime, the right to be reasonably heard at any such proceeding, the right to confer with the attorney for the government in the case, and, critically, the right to be treated with fairness and with respect for the victim's dignity and privacy. The statute was not a suggestion. It was not aspirational language. It was binding federal law. And in the case of Jeffrey Edward Epstein, the United States Attorney's Office for the Southern District of Florida violated it. Not in some technical, debatable way, but in a manner so deliberate that a federal judge would later call it a violation of the law. But here's where it gets disturbing. Source: 18 U.S.C. paragraph 3771, Crime Victims' Rights Act, enacted October 30th, 2004. Pacer, Case 08-80736 CIV. The FBI's investigation into Jeffrey Epstein began in 2005, after the Palm Beach Police Department, under then-Chief Michael Reiter, referred the case to the Bureau. The Palm Beach Police had conducted their own investigation beginning in March 2005, initiated by a complaint from a mother whose 14-year-old daughter reported being sexually abused at Epstein's residence at 358 El Brillo Way, Palm Beach, Florida. That local investigation, led by Detective Joseph Reckery, identified multiple underage victims and produced probable cause for felony charges. When the case was referred to the FBI, the investigation expanded dramatically. According to the Miami Herald's Perversion of Justice series by Julie K. Brown, published beginning November 28, 2018, the FBI ultimately identified approximately 36 girls who had been victimized by Epstein, some as young as 13 and 14 years old. These victims cooperated with federal investigators. They gave statements. They described what had happened to them in Epstein's Palm Beach mansion. They did what the system asked of them. The federal investigation was overseen by the United States Attorney's Office for the Southern District of Florida. The U.S. Attorney at the time was Robert Alexander Acosta, who had been appointed by President George W. Bush and took office in 2005. The FBI prepared a 53-page indictment. According to reporting by the Miami Herald and later confirmed through court filings, that could have charged Epstein under federal sex trafficking statutes, charges that carried the possibility of life in prison. Instead of pursuing that indictment, Acosta's office entered into negotiations with Epstein's defense team. That defense team included some of the most prominent attorneys in the country: Jay Lefkowitz, Kenneth Starr, Alan Dershowitz, Gerald Lefcourt, Roy Black, and attorneys from the firm Kirkland and Ellis. The result of those negotiations was the Non-Prosecution Agreement, executed in 2007 and formalized in connection with filings in the Southern District of Florida, referenced under case number 088099. Under the NPA, Epstein would plead guilty to 2 state charges, 1 count of solicitation of prostitution and 1 count of procurement of minors for prostitution. In Palm Beach County Circuit Court, he would register as a sex offender. He would serve 18 months in the Palm Beach County Stockade. And in exchange, the federal government would not prosecute Epstein, or critically, any of his named or unnamed co-conspirators, for federal sex trafficking crimes. Silence. Background music intensifies slightly. Silence. Suspenseful orchestral tones fade. Every file matters. The powerful bury the truth. But paper has a longer memory than power. I'm Mark Epstein. Next file. Page by page.
Here is the critical fact. During the entire period that the NPA was being negotiated, a period spanning months, the victims were not told. Not a single one of the approximately 36 identified victims was informed that the federal government was negotiating a deal that would end the federal investigation. Not a single one was given the opportunity to be heard. Not a single one was consulted. The Crime Victims' Rights Act required it. The prosecutors knew the law existed, and they chose not to comply. According to court filings in what would become case number 08-80736, CIV in the Southern District of Florida, the victims' attorneys, Paul Castle, a former federal judge and law professor at the University of Utah, and Bradley Edwards, a Florida attorney who had been representing multiple Epstein victims, would later argue that the government went beyond mere neglect. They argued that prosecutors actively misled the victims. Now, if you're still here, it means you can handle the truth. So let me show you what they didn't want you to see. The case that would expose this violation, Doe versus United States, case number 08-80736, CV, filed in the Southern District of Florida, was brought on behalf of 2 victims identified as Jane Doe 1 and Jane Doe 2. Their attorneys, Castle and Edwards, filed the action asserting that the government had violated the CVRA by failing to notify the victims of the NPA, failing to consult with them, and failing to allow them to be heard before the deal was finalized. The case was assigned to Judge Kenneth Amara of the United States District Court for the Southern District of Florida. And what emerged in that litigation over the following decade was a devastating portrait of how the federal government handled the victims in this case. Court filings revealed that during the period the NPA was being finalized, federal prosecutors sent communications to victims and their attorneys that, according to the court's later findings, created the false impression that the investigation was still active and ongoing. Victims were told to remain patient. They were told the case was proceeding. What they were not told was that Acosta's office had already agreed in principle to a deal that would end the federal case entirely. Bradley Edwards would later describe in court filings and in his 2020 book, Relentless Pursuit, how victims had continued cooperating with federal investigators, reliving their trauma in interviews and depositions, while the deal was already effectively done. They were, in his characterization, being managed, kept in a posture of cooperation while the very case they were cooperating with was being dismantled behind their backs. Courtney Wild, one of the victims who would later be publicly identified and who became one of the most prominent advocates for accountability in the Epstein case, has described in public statements and court filings how she felt betrayed by the process. Wild, who said she was first brought to Epstein at the age of 14, cooperated fully with federal investigators. She has stated publicly that she was never informed of the NPA until well after it was executed. Virginia Giuffre, another victim who became publicly known through her own civil litigation, including Giuffre versus Maxwell, case number 15, CV 07433 in the Southern District of New York, has also spoken publicly about the failure to notify victims. Giuffre's case, while focused on Ghislaine Maxwell's role, intersected with the broader pattern of institutional failure to protect the rights of Epstein's victims. This is where the official story falls apart. On February 21, 2019, Judge Kenneth Amara issued his ruling in case 08-80736, CV. After more than a decade of litigation, after years of government motions to dismiss, after arguments that the CVRA did not grant victims the right to challenge the NPA, Judge Amara ruled definitively the United States government had violated the Crime Victims' Rights Act. In his order, Judge Mara found that the government had violated the victims' rights under the CVRA by concealing the existence of the NPA and by failing to provide the victims with notice and an opportunity to be heard. The ruling was unequivocal. It was not a finding of a technicality. It was a finding that federal prosecutors had broken a federal law designed specifically to protect the people they were supposed to be serving. But here's the part that should keep you up at night. Judge Mara's ruling came in February 2019, more than 11 years after the NPA was executed. And the ruling, while declaring the violation, left open the question of remedy. What could be done about it now? Over a decade later, the government had broken the law. The deal had already been served. Epstein had completed his 18 months, much of it on work release, reporting to a private office in West Palm Beach for up to 12 hours a day, 6 days a week. The co-conspirators had their immunity. The federal case was closed. Judge Mara ordered the parties to confer on an appropriate remedy. But before any remedy could be finalized, on July 6, 2019, Jeffrey Epstein was arrested by the NYPD Crimes Against Children Task Force at Teterboro Airport in New Jersey. He was indicted by the Southern District of New York under case number 19, CR 490. The landscape shifted entirely. And on August 10, 2019, Epstein was found dead in his cell at the Metropolitan Correctional Center in Manhattan.
The Department of Justice Office of Professional Responsibility conducted its own review of how the NPA was handled. That report, completed in 2020, found that Acosta had exercised poor judgment in the handling of the case, but concluded that his actions did not constitute professional misconduct. The OPR report acknowledged the CVRA violations, but its scope was limited to professional conduct, not criminal accountability. No federal prosecutor was ever disciplined, demoted, or terminated for violating the Crime Victims' Rights Act in the Epstein case. Pause. Source: DOJ OPR report, released 2020, DOJ press statements. Think about what this means. Congress passed a law in 2004 specifically to prevent victims from being excluded from federal criminal proceedings. 3 years later, federal prosecutors negotiated a secret deal with a man who had abused over 30 children and deliberately excluded those children from the process. A federal judge confirmed the violation 11 years after that, and the government's own internal review called it poor judgment. Pause. Not a crime, not misconduct, poor judgment. Pause. The question this raises extends far beyond the Epstein case. If the Crime Victims' Rights Act can be violated in a case this public, with this many victims, with this much evidence, and the only consequence is a finding of poor judgment, then what protection does the law actually offer? Who does the system serve when it can break its own rules and face no accountability? Pause. Courtney Wild continued to fight. In August 2019, the 11th Circuit Court of Appeals heard arguments on whether the CVRA entitled the victims to rescind the NPA itself. On April 14, 2020, a divided panel of the 11th Circuit ruled against the victims, holding that the CVRA did not provide a basis to undo the NPA. The en banc court subsequently affirmed this result. The victims had been right about the violation. Everyone agreed the government broke the law, but the legal system offered them no meaningful remedy. Pause. Source: 11th Circuit. Case related to 08-80736 CV. Press coverage of appellate proceedings. Let me be absolutely clear about what this episode has documented. It is not a matter of opinion that the government violated the CVRA. It is a federal court ruling. It is not a matter of speculation that victims were kept in the dark. It is established in court filings. It is not a conspiracy theory that the NPA was negotiated in secret. It is documented in the case record. Pause. This is not conspiracy. This is court record. Pause. And there's one more thing worth noting. The Non-Prosecution Agreement did not just protect Jeffrey Epstein. Its co-conspirator immunity clause extended protection to others, named and unnamed, who may have been involved in Epstein's crimes. When the government concealed this deal from the victims, it was not just shielding one man, it was shielding a network. And the victims whose rights were violated, the young women who had cooperated with prosecutors, who had relived their worst experiences in the hope that the system would protect them, were the last to know. Pause. The powerful bury the truth, but paper has a longer memory than power. Pause. If this episode opened your eyes, hit subscribe and the bell icon, because every file matters. Comment below. Should the prosecutors who violated the CVRA have faced consequences? I read every single one. Share this before it disappears from your feed. Pause. Next file. We follow the money. Epstein's financial empire. The accounts, the wire transfers, the institutions that kept his world running. When you see which banks knew what, and when they knew it, you'll understand why they paid hundreds of millions to make it go away. Pause. I'm Mark Epstein, and I'll see you in the next file.